Podcast 6 this week, in week 3 for LLB203 constitutional law, looks at the issue as to whether there is a right to vote contained within the Australian Constitution. And the jurisprudence surrounding whether there is a right to vote very much builds upon the foundation laid by the implied freedom of political communication cases, insofar as that they both are determined or both drawn from inferences from sections 7 and 24 of the Constitution. Let's begin by looking at this statement from Chief Justice French in Roe and Electoral Commissioner. His Honour states that the Constitution requires that members of Parliament be directly chosen by the people. That requirement is a constitutional bedrock. It confers rights on the people of the Commonwealth as a whole. It follows, as Justice Isaacs said in 1912, that the vote of every elector is a matter of concern to the whole Commonwealth. Individual voting rights and the duties to enrol and vote are created by laws made under the Constitution in aid of the requirement of direct choice by the people. And it's that concept of direct choice that has been held to give rise to this so-called right to vote. There have been a few cases that have dealt with this issue. First of all, there was Roach and Roe, which established that there was a right to vote, and so we'll begin by looking at those two cases. And then we'll look at the more recent cases of both Day and Murphy, which were very recent challenges made in 2016, but which were ultimately unsuccessful, which is perhaps a bit of a warning that we should not read too much into the right to vote that the court found in Roach and Roe. Nonetheless, let's begin by looking at those cases. And first of all, it's Roach and the Electoral Commissioner. In that case, Roach challenged the constitutional validity of the 2006 amendments to the Commonwealth Electoral Act that changed the voting entitlement for prisoners. The effects of these 2006 amendments removed the entitlement for people serving less than a 3-year term of imprisonment to vote at federal elections. All prisoners were therefore no longer able to vote. They were excluded from voting. In 2004, Roach was sentenced to 6 years imprisonment for burglary, including negligent injury and endangerment. She argued that she should have the right to vote, and therefore challenged the basis of those 2006 amendments to the Commonwealth Electoral Act. The court held in a landmark 4-2 decision that the 2006 amendments were inconsistent with the system of representative democracy established by the Constitution. The majority consisted in that case of the then Chief Justice Gleeson, who authored his own opinion, as well as Justices Gummow, Kirby and Crennan, who authored a joint opinion. Justices Hayne and Hayden delivered separate dissenting opinions. Chief Justice Gleeson held that the right to vote was mandated by sections 7 and 24 of the Constitution, which requires that the senators and members of the House of Representatives be directly chosen by the people of the state or the Commonwealth respectively. Chief Justice Gleeson noted that in 1901 those words did not mandate universal adult suffrage. Indeed, at the time of Federation in 1901, women were not able to vote, nor were Indigenous people able to vote. But His Honour went on to say that the words of Section 7 and 24, because of changed historical circumstances, including legislative history, have come to be a constitutional protection of the right to vote. So therefore, Chief Justice Gleeson was finding that there was a right to vote contained in the Commonwealth Constitution. However, His Honour didn't observe that the Parliament retained the power to legislate exceptions. At paragraphs 7 and 8, Chief Justice Gleeson said that the Constitution leaves it to the Parliament to define those exceptions, but its power to do so is not unconstrained. Because the franchise is critical to representative government and lies at the centre of our concept of participation in the life of the community and of citizenship, disenfranchisement of any group of adult citizens on a basis that does not constitute a substantial reason for exclusion from such participation would not be consistent with choice by the people. To say that, of course, raises questions as to what constitutes a substantial reason, and what, if any, limits there are to Parliament's capacity to decide that matter. And so His Honour then gives us some examples of what perhaps would not constitute a substantial reason. For example, an arbitrary exception would be inconsistent with choice by the people. There would need to be some rationale for the exception. The definition of the excluded class or group would need to have a rational connection with the identification of community membership or with the capacity to exercise free choice. So that was Chief Justice Gleeson. The other members of the majority, Justices Gamow, Kirby and Crennan, approached it from a slightly different angle. Their Honours observed at paragraph 81 that voting in elections for the Parliament lies at the very heart of the system of government for which the Constitution provides. This central concept is reflected in the detailed provisions for the election of the Parliament of the Commonwealth in what is otherwise a comparatively brief constitutional text. This plurality opinion also accepted that there had to be exceptions to the right to vote, or members of the majority accepted that there had to be a substantial reason for exclusion, but while Chief Justice Gleeson held that an arbitrary exception would be inconsistent with choice by the people, Justices Gamow, Kirby and Crennan employed the test of whether the disqualification is reasonably appropriate and adapted to serve an end which is consistent or compatible with the maintenance of the constitutionally prescribed system of representative government. And again, that language should be familiar to you from our discussion of the implied freedom of political communication. That joint opinion seems to be adopting a very similar approach with respect to the right to vote. A few years later, there was another challenge, also based upon the amendments in 2006, and this was the case of Rowe, an electoral commissioner. Now, Rowe challenged again, amendments made in 2006, which reduced the time within which persons could make a claim for enrolment to vote or to transfer enrolment after elections had been called. Now, prior to this change in 2006, new electors could enrol, previous enrolled electors could re-enroll, and enrolled electors could update their details in 7 days following the issue of the writs. The issue of the writs is the formal process by which the election is called. The close of rolls period for new enrolments, re-enrolments and detailed updates had been 7 days since the 1984 federal election. However, as a result of these changes in 2006, for the 2007 and 2010 federal elections, new enrolments and re-enrolments had to be received by the Australian Electoral Commission by 8 p.m. on the day of the issue of the writs, and changes to enrolment details had to be received within 3 days of the issue of the writs. So again, in Rowe, the challenge was that this change that was introduced in 2006 was unconstitutional insofar as it was incompatible with this right to vote that the court had found in Roach. Now in Rowe, the court held by a 4-3 majority that these provisions did indeed infringe this right to vote. In particular, they said that these provisions contravened the requirement contained in Section 7 and 24 of the Constitution that members of both houses of the Commonwealth Parliament shall be directly chosen by the people. Now, the majority in this case consisted of Chief Justice French with Justices Gamow, Bell and Crennan. Again, there were some slightly different reasons adopted by the majority. So Chief Justice French stated at paragraph 2 that an electoral law which denies enrolment and therefore the right to vote of any of the people who are qualified to be enrolled can only be justified if it serves the purpose of the constitutional mandate. If the law's adverse legal or practical effect upon the exercise of the entitlement to vote is disproportionate to its advancement of the constitutional mandate, then it may be antagonistic to that mandate. If that be so, it will be invalid. Now, while Chief Justice French concluded that the rationale for the 2006 amendments to avert the future possibility of electoral fraud were legitimate in terms of the constitutional mandate, the particular provisions in question were not proportionate to that end, and as such they were unconstitutional. Now, Justices Gamow and Bell, who wrote together with Justice Crennan, who broadly agreed, also applied a proportionality test, taking into account the practical effects of the 2006 amendments on the capacity for qualified persons to participate in an election. Their Honours said, that is, Justices Gamow and Bell said, that a legislative purpose of preventing fraud before it is able to occur, where there has not been any previous systemic fraud associated with the operation of the 7-day period before the changes made by the 2006 Act, does not supply a substantial reason for the practical operation of the 2006 Act in disqualifying large numbers of electors. That practical operation goes beyond any advantage in preserving the integrity of the electoral process from a hazard which so far has not materialised to any significant degree. So again, similar but slightly different approach to that taken by Chief Justice French. That said, they were looking and applying some sort of proportionality test, and while they accepted, in terms of the majority, that there was perhaps some justification for it in terms of there being some purpose, the laws were disproportionate to achieving that particular purpose. And in large part, that was because there was no evidence of systemic voter fraud that had taken place at previous federal elections. Now, in separate dissenting judgments, Justices Hayne, Hayden and Kiefel each held that the provisions did not contravene any limitation imposed by the Constitution on the legislative power of the Commonwealth to fix the date and time after which claims for enrolment or transfer of enrolment may not be considered before an election. In particular, the dissenting judges placed emphasis on the failure of the plaintiffs to fulfil the legal obligation of timely enrolment, attributing primary responsibility for their exclusion from voting to their inaction rather than the changes made by the 2006 amendments. Okay, so that was Roach and Roe, which established this basic principle of a right to vote. As I said at the outset, there have been two more recent cases that have considered this issue. The first was Day, an Australian electoral officer for the state of South Australia. Now, this dealt with changes to the Senate voting system that were passed in 2016. These changes allowed electors to vote above the line on the Senate ballot paper by numbering at least 6 squares sequentially. The list of candidates marked 1 were now allocated preferences in the order in which they appear, then followed by the list of candidates marked 2, and so on. This system replaced the previous system by which electors could make a single above-the-line vote by marking 1 for a particular group vote, after which preferences would be allocated according to that group's list of preferences. Now, the plaintiff, Senator Day, contended that the new form of the ballot paper as a whole and this new method of voting prescribed above the line contravened Sections 9 and 7 of the Constitution because it constituted more than one method of voting and did not meet the requirements that senators be directly chosen by the people, and that it contravened the principle of proportionate representation, and that it also prevented a free and informed vote, and in the alternative, that it contravened a constitutional principle of representative government and the freedom of political communication. So there were those basic 5 arguments, argument A through to argument E. The respondents contended that each of those arguments misconstrued the effect of the provisions or the requirements of the Commonwealth Constitution. The court held unanimously that none of the arguments raised by Senator Day had any merit. Argument A failed because the constitutional method requirements are relevant to national uniformity of ballot paper approaches and are not a formal constraint on Parliament's power to legislate on Senate election methods unconnected to national uniformity purposes. The court rejected argument B because above-the-line voting is still just as much a direct vote for individual candidates, albeit through a party list, as below-the-line voting. Argument C, which rested on an asserted principle of directly proportional representation, was rejected because no such principle existed in the context of the Commonwealth Constitution, and because while many voters may be encouraged to vote above the line, that did not constitute any disenfranchisement in the illegal effect of the voting process. Argument D was rejected because the ballot paper was not misleading and did not fail to inform the voter of the range of voting options. And argument E, which the court had termed a catch-all argument, repeated the points made in those other arguments and was rejected for those same reasons. So this challenge by Senator Day really had no merit. And I think most experts, academics, and lawyers expected it to fail, and indeed it did. Perhaps the more interesting challenge that arose out of the 2016 election was the case of Murphy and the Electoral Commissioner. Now, this built upon the foundation that the court had laid down in Roe, an electoral commissioner, which dealt with the timelines by which you could get on the electoral roll or update your details on the rolls. So this was a challenge to the Commonwealth Parliament's power to legislate to suspend the processing of claims for enrolments to vote and transfers of enrolments to vote from 7 days after the issue of the writs for an election. So as we saw when we were talking about Roe and the Electoral Commissioner, those reduced timelines were struck down as being unconstitutional in that case, and so they reverted back to the previous timelines which had been in place since the 1984 federal election. Now, in this case, Murphy and Electoral Commissioner, they said that even those deadlines were unconstitutional. The plaintiffs argued that the principle in Roe and Electoral Commissioner, in which the court held that the Parliament could not close the rolls on the day the writs are issued, should be extended up to polling day, and that the current arrangements contravened the requirements contained in Section 7 and 24 of the Constitution. Now, central to the plaintiffs' arguments was that technological improvements and the availability of resources for extending the period before closure of the rolls closer to polling day means there is no substantive reason to suspend the rolls from 7 days after the date of the issue of the writs. Now, the court held here unanimously, albeit for different reasons in 6 different judgments, that the relevant provisions of the Commonwealth Electoral Act 1918 were valid. So, the court held here, for a few different reasons, that the challenge was unsuccessful. Now, one reason was that the plaintiffs could not establish that the impugned provisions amounted to a burden on the constitutional mandate of popular choice. The number of the justices observed that a suspension period has been part of electoral law since Federation, and thus no diminishment of the extent of the realisation of the constitutional mandate of popular choice was at issue in the special case. And even if there was a relevant burden, the court held that it was still justified by a substantial reason. The court said that as a part of any coherent electoral system, the impugned provisions advanced the orderly and efficient conduct of elections. It ensured that there would be few delays in declaring electoral rolls, and it achieved accuracy and certainty in the lists of the electors produced for polling day. So there was a substantial reason, if there was indeed a burden. The plaintiff's argument also relied upon a premise that a law burdening the constitutional mandate could not be valid unless it maximised opportunities for electoral participation. The court rejected this premise, saying that it was not supported by the Constitution nor by the High Court's decisions in Roach and Roe. The court also resisted the opportunity to basically be required to legislate from the bench. They said that analysing whether the impugned provisions were justified by reference to alternative regimes in state electoral systems was inappropriate, as it would involve the court in a legislative judgment which was beyond its judicial role. So as I said, although Murphy and Electoral Commissioner was a more interesting challenge, it ultimately failed as well. Now, one thing that is not now clear following the High Court's decision in Murphy and Electoral Commissioner is the extent to which the concept of proportionality is still going to be used in these cases dealing with the right to vote. The court actually seemed to move away from the notion of proportionality, certainly moved away from the stricter, clearer proportionality test laid down in the implied freedom of political communication case of McCloy and New South Wales. So it will be fascinating to see in future cases as to whether the right to vote jurisprudence develops its own theoretical framework or whether it also reverts to a clearer proportionality approach. But certainly Murphy seems to move it away from a proportionality approach that seemed to be in ascendancy in Roe. I'd now encourage you to go away and read the relevant parts of the textbook and also to do a little bit of reading about the Bill of Rights, because all of the podcasts this week have dealt with the issue of rights, and there is repeated calls that Australia should adopt some sort of either constitutional or legislative Bill of Rights. So I'd encourage you to look at that material produced by the Australian Parliament and then form your own opinion and share that on the discussion board as to whether you think Australia should have a Bill of Rights, why or why not. Now that then brings us to an end of the Week 3 material, or the equivalent of Week 3 material. The next week's material deals with the interpretation of Commonwealth heads of power and the characterisation of law. So we're dealing here primarily with legislative power. And then we're going to look at two specific heads of power, the trade and commerce power and the corporations power. See you next week.